Okay, I've received a motion 60B. It's a legal document for Schaeffer's case. Schaeffer seems real excited about it. You guys know I'm not a legal guy. I'm the opposite of a legal guy. But I did scan it. It's a 3-page document, and I've put it in Schaeffer's DropBox. And so Schaeffer's DropBox is available to the public, and I'll put the link. And if you want to download it and look at it yourself, you're certainly welcome to do so. I will read it for those of you that are interested in legal things. And we'll just at least say that we've uploaded it to YouTube, and we've also pointed people where they can download it themselves. Again, Schaeffer seems very excited about this thing. Since I'm not a legal guy, I don't know what to, I hope it is a good thing. It's just legal papers. I'd rather read the Bible, right? But anyway, this is important. I understand there is a place for this kind of stuff, I guess. That's just not my thing. But anyway, here we go. In the United States District Court for the District of Columbia, in regards to special proceedings, miscellaneous number 09-0198 EGS, notice of filing of report to Honorable Emmett G. Sullivan. Pursuant to the court's order dated February the 8th, 2012, the undersigned hereby files the report to Honorable Emmett G. Sullivan of investigation conducted pursuant to the court's order dated April the 7th, 2009, and an addendum containing comments and objections to the report which were provided to the undersigned by the subjects of the investigation: Joseph W. Bottini, James A. Goki, Nicholas A. Marsh, Brenda K. Morris, Edward P. Sullivan, and William P. Welch III on March the 8th, 2012. Respectfully submitted, Henry F. Schulke III, D.C. Bar number 91579, Special Counsel, William Shields, D.C. Bar number 451036, Janice Schulke and Wechsler, Washington, D.C., dated March 15th, 2012. That's the first page. The second page. Case 1:09-MC-00198-EGS, Document 84, filed 3/15/12, page 514 of 525. United States versus Bagley, 473 U.S. 667-682-683, 1985. The Supreme Court and the government identified the danger of the defense, and he highlights, when prosecutors make an incomplete response to a specific request for Brady material. The government notes that an incomplete response to a specific Brady request not only deprives the defense of certain evidence, but also has the effect of representing to the defense that the evidence does not exist. In reliance on this misleading representation, the defense might abandon lines of independent investigation, defenses, or trial strategies that it otherwise would have pursued. We agree that the prosecutor's failure to respond fully to a Brady request may impair the adversary process in this manner. And the more specifically, the defense requests certain evidence, thus putting the prosecutor on notice of its value. The more reasonable it is for the defense to assume from the non-disclosure that the evidence does not exist, and to make pre-trial and trial decisions on the basis of this assumption. Emphasis added, citation omitted. The Brady disclosure in Stevens was not just incomplete. Mr. Bottini, one of Cox's prosecutors, Mr. Goki, and Mr. Marsh falsely represented that there was no evidence that Mr. Allen asked Miss Tyree to lie. NAPUE, N-A-P-U-E. In NAPUE versus Illinois, 360 U.S. 264,269, 1959, the Supreme Court held that a prosecutor may not knowingly use false testimony, including testimony that relates only to the credibility of the witness, to obtain a conviction or allow such testimony to go uncorrected. It is established that a conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. The principle that a state may not knowingly use false evidence, including false testimony, to obtain a tainted conviction implicit in any concept of ordered liberty does not cease to apply merely because the false testimony goes only to the credibility of the witness. The jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence, and it is upon such subtle factors as the possible interest of the witness in testifying falsely that the defendant's life or liberty may depend. Citations omitted. See also United States v. Freeman, 650 F.3d, 673, 680, 7th Circuit, 2011. And then this part is highlighted. NAPU does not require that the witness could be successfully prosecuted for perjury. United States v. Boyd, 55 F.3, D, 239, 243, 7th Circuit, 1995. In this area of the law, the government principle is simply that the prosecutor may not knowingly use false testimony. This is highlighted again. This includes half-truths and vague statements that could be true in a limited literal sense but give a false impression to the jury. It is enough that the jury was likely to understand the witness to have said something that was, as the prosecution knew, false. Though the rule of Brady arguably applies to NAPU violations, United States v. August, 427 U.S. 97 at 103, 1976, the standard of review under NAPU is stricter than the Brady standard. And then this is highlighted. A NAPU violation is a hair trigger for reversal. United States v. Gale, 314 F.3d, 1,4, D.C. Circuit, REH''G, denied, 326 F.3d, 228, D.C. Circuit, 2003. Whereas the prosecution's knowing use of false testimony entails a veritable hair trigger for setting aside the conviction. And this next part is highlighted. Any reasonable likelihood that the false testimony could have affected the judgment of the jury, see Augers, 427 U.S. at 103, non-disclosure of exculpatory evidence, including impeachment evidence, is governed by a more general... Hey, babe, do you want to answer this?
Yeah, I'm right here.
Okay.
Hello? Hello?
Okay, sorry that the phone was ringing and just got to deal with reality. I can't start over. Okay, see Augers, 427 U.S. at 103. Non-disclosure of exculpatory evidence, including impeachment evidence, is governed by a more general standard. Favorable evidence is material and constitutional errors results from its suppression by the government. If there is a reasonable probability that the evidence been disclosed to the defense, the result of the proceeding would have been different. Mr. Allen's eve of trial recollection of his CYA conversation with Mr. Persons in 2002 contradicted his statement on April 2008 to Mr. Bottini, Mr. Goki, Mr. Marsh, Mr. Edward Sullivan, and Agent Kepner, that he did not remember speaking to Mr. Persons about the Torricelli note. Those inconsistent statements were Brady/Giglio information, which were required to be disclosed to Williams and Connolly, but were not. The prosecutors and Agent Kepner testified in this. Okay, that's the 3 pages. I've scanned all of these pages and uploaded them to Schaeffer's Dropbox. I'll put the link in the description bar. I don't really know what all this means. I gather that the prosecutors knowingly used testimony on the witness stand that they knew was false, and they used evidence that they knew was false. And it appears that Schaeffer has found where this is a violation of legal code, and he calls it a hair trigger for reversal. The only concern that I have is that our federal courts and courts in general are run by sons of Belial, wicked reprobates. And even though you might find them in error, they still just do the wicked thing anyway, even though that, they're wrong. But I pray that this is useful for whoever wants to help Schaeffer from a legal perspective. But you guys know that I'm not the legal guy, but that doesn't mean that something can't be done anyway. God bless.